What happens if a relative signed an affidavit saying there was no will, but a valid will is later found? If a valid will turns up later, the estate usually needs to shift from being handled as if there were no will to being handled under the will. The next step is to file the will with the probate court in the county where the person lived at death so it can be admitted to probate. Once the will is accepted, the person named in the will as executor may be the one with authority to act instead of the person who signed the earlier affidavit. If someone already collected money or other property using that affidavit, the court can require that person to turn over what is left and provide an accounting showing what was collected, what bills were paid, and what was distributed. If the affidavit was signed as an honest mistake, the usual focus is correcting the administration and fixing any wrong distributions. But if the statement was knowingly false, it can create serious civil liability and possible criminal exposure. Timing can matter a lot when real estate is involved, so the will should be filed as soon as it is found to avoid title problems and complications with later buyers or creditors, especially if property is in another county or another state.